Make sure my ringer's down.
Is it Datavia with an A or
Yes.
Datavia with an ER?
Well, it's a booking numbers.
I found it.
Morning, Mr. McLean. How are you, sir?
Very well. Yourself?
Doing good too. Thank you. I'm all right. Let's get started with this
Famous fault.
proper SAP calendar. Good morning, Ms. Falk.
Good morning, Your Honor. Good morning, PD McLean. How are you today?
Very good.
Are you going solo today, Mr. McLean?
Oh, no, I have two colleagues with me today. They're just doing other things at the moment, but we're going to start with one of my clients, I believe.
Okay.
Well, Your Honor, I will say my partner was unexpectedly ill, so I am solo today. So I would ask everyone to pack their patience.
All right, will do. Thank you very much. Okay.
Yes.
All right, let's start with ACDC since no one seems to be in courtroom 2 at the present time. Good morning, my name is Judge Lal, and we're going to begin with our misdemeanor all-purpose calendar. Please remember that if you are charged with one or more misdemeanor charges, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Today, we're going to determine how you would like to move forward with your case. Either you'll be considering a offer from the prosecution to enter a plea, or you enter a plea of not guilty, and the case will move forward for trial. Okay. Right, hopefully that was my only technical hiccup this morning. All right. Who do we have at ACDC? Good morning, Deputy Milton. Could you please tell me your name, ma'am? Your
Session 33 and 34, Kimberly Jackson.
Thank you. '33 and 34. And I'm sorry, Mr. McLean, I didn't get the, I couldn't read the email from Ms. Vigiletti about the announcement, so that I'm going to count on you. Tell me how you plan to move forward. This is
Not guilty bond request on 3334, and on the bond request, I might need to be informed about what the current bond is.
okay. Kimberly Jackson's accused of 2 counts of simple battery family violence in case 19 CR 7758F from September 9th, 2019. The case has not been resolved to date, and she's got a bench warrant for failure to appear on July 2nd. No, I'm not sure when was the bench warrant issued, but she does have a bench warrant. The case is 24 FTA 876. Ms. Jackson, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. I understand that you will be entering a not guilty plea. Mr. McLean, will you be submitting a waiver of arraignment?
Yes, Your Honor. Yes, Your Honor. I will make a note to the right of my notes on filing the waiver today.
All right, so on position 33 and 34 will be a waiver of arraignment, which means that your case is going to be rescheduled for trial. In the meantime, let's see. I am just trying to pull up the bond amount at the present time. And
It's 8,000, Your Honor. It's a split bond, 4,000 surety, 4,000 cash.
okay, that appears to be for the failure to appear on the cash, on the surety bonds on the simple battery, one of the counts, and 4,000 on the bench warrant. Okay, that's what it is, Mr. McLean. Yes, sir.
Thank you.
And what's your argument for bond modification?
Your Honor, she did not miss court willingly or knowingly. We did have a good discussion about the methodologies that can cause a person to never miss court and not rely upon the mail and not rely upon bonding companies if there is one. In the future, Your Honor, she will come down to the clerk's office every 3 weeks and check in person, not relying upon a phone call either. So she is set to succeed on never missing court. What happened to the previous notice, what date the FTA occurred? She says, I would have come to court if I'd known. There are probably details we can get into there, but we don't have those yet.
This is not her first time missing court. This is her second time with a bench warrant in this case. The last time was in November of 2022, and the next was in April of 2023.
Okay. Now, in this, Your Honor, looking at the back of my visitation slip, I did note that during this time period, she gave birth to a child, another child, and also she had a diagnosis of congestive heart failure at some point. So I think that she probably had a lot of things going on in her life, and that would have added to the discombobulation.
All right. Anything to add, Ms. Falk?
Yes, Your Honor, you are correct. This is the second bench warrant on the same case. The second time she made bond, she provided a new address. That address came back on December 19th, 2022 as returned to sender, not deliverable as addressed. So I understand missing court once, making a new bond and providing new information, but this is the second time she has missed court. At this point, Your Honor, I don't think it is, I think it is unreasonable to say that, this is just a mistake, especially when she bench warranted, gave a new address, that new address came back returned to sender, and now we're back here in court, and the case just continues to drag on because of her failure to appear.
Okay, thank you. On the simple battery family violence in which she's got a 4,000 surety, I'm going to amend that to a 4,000 signature bond through the jail. Same conditions apply, no further violent contact with Curtis Jackson and so forth. For the bench warrant is going to be a $1,000 surety bond. This is her second do-over. She's well aware of the requirements of keeping in touch with court, maintaining an address, and showing up for court. Again, no further violent contact with Curtis Jackson. The cases are scheduled for trial. Thank you.
Very good. Thank you.
Next, we can go to position number 19 and 20, David Frazier.
Are we in courtroom 2 now, Deputy?
Yes, Your Honor, yes.
All right. This is the announcement for the individuals in courtroom 2. My name is Judge Lal, and this is an all-purpose calendar for today, July 18th, 2024. These cases have already been accused, so today we're going to determine how you would like to move forward with your particular charges. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and you will be appointed counsel to represent you if you can't afford an attorney. Position 19 is David Frazier, who's got 2 cases. The first one is 21 CR 3455B for DUI and hit and run from July 27, 2020. And the second one is a bench warrant for failure to appear in court in September of 2023. Mr. Frazier, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
Not guilty bond request.
All right. Would you be filing a waiver?
Yes, Your Honor.
Okay. In both cases, a waiver of arraignment is going to be submitted. And Mr. Frazier, your attorney is going to be moving forward with a entering a document with your not guilty plea, and your cases will be rescheduled for trial. With regards to Mr. Frazier, Falk, would you happen to have his bond information?
Yes, Your Honor, I can pull that up. And Your Honor,
We have,
if we could, after addressing this, address the previous case, there is something the state needs to put on the record.
Okay,
But this is a $1,000 failure to appear bond, Your Honor.
okay.
And
Okay,
it looks like he failed to appear, just for the court's edification, on September 26th of 2023. That was what led to this bench warrant.
all right. Mr. McLean?
on the screen. Your Honor, he states that he did not purposefully miss court. This case is from 2020. It is a case of mistaken identity because there was a white van and it wasn't his white van. But that will be, that'll all come out at trial. Your Honor, he works at Wendy's. He has worked in the past at Six Flags and has a stable address.
Bond is set at $1,000 signature bond through the jail. Mr. Frazier, this is an open active case. It's a serious case. And you need to make sure that you maintain a current address, keep in communication with your counsel, and show up to court when summoned. Otherwise, you get to spend, 14 days with us in jail because of failure to appear. Thank you.
Next,
Individuals who are on Randall Briggs' iPad, could you please stop your video? You can come on when the individual whom you're interested in addressing is being called to court. All right, so please stop your video until we are ready to address your case. Same announcement for Karen Nwosu. All right, Ms. Falk, what was the announcement that you wanted to make for the Kimberly Jackson case?
Your Honor, so I just do want to point out that in accordance with SB 63, I'm still getting, familiarized and having to remember that law. Because she had a previous FTA within the last 5 years, she's actually not eligible for a signature bond on that family violence simple battery. So Your Honor would either need to do it through pretrial services or as a surety bond. I will point out that she's previously been given a $4,000 surety bond in this case that led to her bench warning again.
I'll do a signature bond through pretrial. Mr. McLean, signature bond through pretrial services.
Okay. Got it.
For one, and she can do telephonic reporting.
Right.
What position is this, Your Honor?
This is position 33.
Okay, thank
And
you.
34 is still the 1,000 surety.
Correct.
Got it. Hold on.
ACDC, who do you have at the front?
Position 37, Quinetta Jones.
Okay, this is State versus Quinetta Jones, accused of criminal trespass from July 2nd, 2024, case 24 CR 4365B. Ms. Jones, you've been advised of your right to remain silent, and your attorney is
You get credit. for that.
Mr. McLean. Is that your client, Quinetta Jones, on screen?
Yes, Your Honor.
All right, how would you like to proceed?
Let's go back to Ms. Jones. Hold on. It's number 37. That's negotiated plea, Your Honor.
All right, thank you. Ms. Jones, if you please raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes, ma'am.
Okay. It appears that we are addressing a second case. It's 24 CR 3170B, in which you were accused of criminal trespass and simple battery at a public vehicle or station. Okay, Ms. Falk, what's the recommendation for Ms. Jones in both these cases?
Position 37, Your Honor, is going to be 12 months served, 32 days, credit for time served, 16 days. From July 3rd, 2024 to today, balance suspended, actually. Stay away from Underground Atlanta, located at 66 Alabama Street Southwest in Atlanta. The add-on position 24 CR 003170B is for criminal trespass, simple battery in a public vehicle or station. We are going to ask for 12 months serve, 12 days, credit for time served, 6 days, from May 20th, 2024 to May 23rd, 2024. That is also balance suspended, no further contact with Summer Bostic, and stay away from all MARTA locations. This is going to run concurrent with the previous case. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. Ms. Bostic does agree with the plea offer. We would like to sound for her, but she did state she would not be here today.
All right, Summer Bostic, are you on Zoom? There's someone on iPhone too, but I don't know who that is. All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do, and he does, Your Honor.
All right. You said he does? I've got a female on Zoom, so did you mean she?
Yes, Your Honor. Sorry, yes.
Okay,
We're flipping through the list here.
all right. Ms. Jones, you understand that you have 2 open cases at the present time with the Fulton County State Court.
I'm aware as of now.
All right. And these are the 2 open cases of which you are considering entering a guilty plea. Is that how you're moving forward?
Yes, ma'am.
And you understand that you'll have to stay away from certain locations.
Yes, ma'am.
Okay. Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood your conversation with your attorney?
Yes, ma'am.
Are you satisfied with the services?
Yes, ma'am.
And have you considered the charges in both these cases involving criminal trespass on at Underground Atlanta, and the other one regarding an alleged attack on an individual at MARTA?
Yes, ma'am.
And are you entering a guilty plea to both cases freely, willingly, and voluntarily?
Yes, ma'am.
You understand that if you enter such a plea, you will not get a chance to go to trial. You will not confront your accuser, challenge the evidence brought against you, and have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass on July 2nd, 2024 at the Underground?
Yes.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended. You are to stay away from the Underground Atlanta, located at 66 Alabama Street in Southwest Atlanta. Since you're required to stay 200 yards away, you are not allowed to return to any store at the Underground Atlanta. Do you understand?
Yes, ma'am.
How do you plead to simple battery and criminal trespass at MARTA?
Guilty.
For the simple battery, your sentence is 12 months to serve 12 days, credit for time served 6 days, no contact with Summer Bostic, and to stay away from all MARTA locations. You're not allowed at any MARTA station, bus station, train, as well as their facilities, including their sidewalks, parking lots, and bathrooms. Do you understand?
Yes, ma'am.
On the criminal trespass, that will be 12 months concurrent with the simple battery charge. That concludes your case.
Can I ask a question?
Go ahead.
Do that mean that I'll be getting released today?
If you have no other cases and any other holds, you'll be released within 24 hours, but please make sure you stay away from the locations that are constructed.
Okay. All right. Thank you.
Mhm. Next,
Next, Your Honor, we have position number 22, Mr. David Glass.
David Glass is accused of 1 count of simple battery and a 2nd count of a charge in which we're going to waive sounding. Mr. Glass, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Your case number is 24 CR 4650Y. Mr. McLean, has your client been shown both the charges in this case?
Yes, Your Honor, it is my judgment at this time, based on my conversations yesterday and this morning, that Mr. Glass needs further discussions for an attorney such as myself or anybody on my staff to determine whether he truly understands the elements of the offense charged. Therefore, I'm going to ask us, our procedure is we ask a social worker to confirm our impression before we actually pull the trigger on asking for a evaluation. So I would like to reset this, bring him to have a social worker. The offer is a considerable amount of extra time, so there won't be any harm to his freedom interests.
The case is reset to July 25th, pending a social worker interview.
Thank you, Your Honor. All right, see you later.
Next,
Good to
we
see
can
you,
go
man.
to position
Yeah.
number.
Your Honor, when you finish with courtroom 2, I would like to do position 46, Ms. McLeod's client.
Okay. Courtroom 2, who do we have next?
Position 35 and 36.
Thank you. This is State versus Gary Jones on position 35 is 18 CR 6275Y, in which he's accused of battery. And position 36 is a bench warrant 24 FTA 875. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
Not guilty. I believe he has a $2,000 surety bond on the FTA itself, and he's going to ask the court for a signature bond.
Are you filing a waiver of arraignment, Mr.
Yes.
Okay, so this
Yeah.
waiver of arraignment on the battery charge and further notice for trial. And yes, your argument on bond?
Let's see. He had no notice. He does not understand what happened to the mail. And, as with my other clients, we did explain and discuss methods to not rely upon the mail. I expected certain people to be on Zoom today to back up the notion of his trustworthiness for his efforts in not missing court. May I sound for his sister?
Go ahead.
Is she on it? Okay, it's Chandra iPhone. There it is.
All right.
Uh,
Ms. Chandra, if you are related to Mr. Gary Jones, please unmute and start your video. You have to unmute. We can't hear you. Nope, no sound. There we go.
There we go.
Okay,
All right. Ms. Chandra, are you related to Gary Jones?
yes, ma'am, that's my brother.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Where does he live?
817 Gould Street with me
Which is where?
in Savannah, Georgia.
Okay. Has he always lived there?
Yes, since he came home, yes.
When did he come home?
In January
Of what year?
of 2024.
Okay. All right. Mr. McLean, what's your question of Ms. Chandra?
Ms. Chandra, do you have good mail service?
Yes, sir.
Okay. Do you have any clue as to why he missed his court before?
We didn't get any notification at all. That's why we was confused about when they said he had a warrant. We were so confused because he just had came home in January. So we was like, what's going on? I said, this had to be a mistake because we've been calling, I guess we was calling the wrong bondsman or something to make sure. We've been calling every month, making sure that we haven't got a court date or anything.
Please stop, please stop. All right. Ms. Falk, do you have any opposition to this set aside?
Yes, Your Honor, I do, mainly because it is the second FTA on the same case. He actually just FTA'd on this same case January 5th of 2024, was confined for 9 days, released, and now bench warranted again on the case, failed to appear on March 28th of 2024 for his plea and arraignment, at which point the case was again issued a bench warrant. He was released on his previous bench warrant on January 13th of 2024 and given a $1,000 surety bond, and now has bench warranted a second time on the same exact case. This is such a short period of time from the first offense to the second offense. I'm not confident he is going to reappear on bond, which is why a $2,000 surety bond was set this time, as opposed to the $1,000 surety bond that was set the last time he bench warranted. So it doesn't appear that the judge on this case, which would have been, I believe, Judge Edie, was confident about his returning to court either, given the fact that he failed to appear twice in a 3-month period.
Okay, can I ask a question? What
Very well.
address do you have?
That's what I'm trying to figure out. Yeah, I'm going to set aside the bench warrant. It appears that the court sent it to a Abercorn Street and not to the
Okay,
street. And no, I don't need any more commentary. Thank you.
okay.
Mr. McLean, I'm going to set aside the bench warrant and reinstate the original bond.
Understood. That original bond is going to be,
I don't know what was it, 2,000? In other words, I'm going to vacate the arrest of the bench warrant.
right.
So there shouldn't be any holding him and reinstate the original bond. However, he bonded out the last time.
Right. I only saw the 2,000 on the FTA and have not researched what his previous bond
Which
situation.
is being vacated, so he
Right.
should be released. So all you need to do is submit an order to vacate the bench warrant
Okay.
and reinstate the original bond, and he shall be released. He shall maintain a current address, which is that Good Street location, and keep in communication with the courts.
Very good. I'll prepare such an order.
No,
Okay. Understand. Thank you.
Honor.
Mr. Tay, yes, what's the question?
Yes. So I see that the Spanish translator and Alpharetta is on, and I need to interview. So I was wanting to know if I could be in a breakout room with Alpharetta and Miss Chansey.
All right, thank you for letting me know. Miss Champion, Mr. Jordan, could you please place the Zoom panel Alpharetta, Miss Hoda, and Miss Chansey, Chansey, into a breakout room, please?
I got it.
Thank you, sir. All right,
Your Honor,
yeah, what was that position number, Miss Deputy Milton? You said it was 42, 46?
46, Ms.
40.
Price.
Okay.
And then one more, I have position 52, Mr. Valadares. He's Spanish too. So when I finish the other two females,
You'll need the interpreter for the interview. Okay.
correct. Thank
All
you.
Remind me when we're done.
Yes.
This is Diella Maria Price, position number 46, accused of battery, family violence from June 30th, 2024. Ms. Price, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
Actually,
I am.
That'll be-
Oh, I'm sorry, Ms. McLeod. Yes, you're right. I do beg your pardon. It was Ms. McLeod. Sorry, Ms. McLeod. How are we proceeding with your client, Ms. Price?
This is going to be a negotiated plea, except for one small aspect, Your Honor, the contact.
All right. Right now, the state has no further contact with Clinton Sumlin. And what's the small little thing?
Mr. Sumlin, I have spoken with him, and he indicates that he does want contact with her. I believe he's on the Zoom, Your Honor, and would like to speak about that because he does want contact. My client wants contact. They are in a relationship.
Clinton Sumlin, if you're on Zoom, please unmute and start your video. Ms. Falk, have you had any updates regarding contact?
I am looking for that information now, Your Honor.
Okay, Let's begin with Ms. Price, and then if he pops in during the course of this proceeding, then we'll definitely address his wishes. Ms.
Your Honor, actually is at G33. So
Hello?
the deputy helped him log in, so he should be on.
Okay, Mr. Sumlin,
Yes, ma'am.
okay, could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, do you know Diella Maria Price?
Yes, ma'am.
All right, looks like she's entering into a plea today. The question is whether she should have contact with you or no contact with you. What's your wish?
I want to contact. We live together.
All right, you're not concerned that you may have another altercation with her?
No, ma'am. No, ma'am. It ain't gonna be none of that. No, ma'am.
All right. Ms. Falk, any questions of Mr. Sumlin?
Yes, Your Honor. Mr. Sumlin, has anything like of this nature happened before?
No, ma'am.
And my understanding is you told police that this had been due to her not keeping up with her health care. Is that correct?
No, her medication. Her medication. That's all it is. She just needs a medication. That's the only thing I want to take her medication.
Okay. So, Your Honor, we would be agreeable to revising the no further contact to no further violent contact. I know that we did request an MHET on this one as part of the plea.
All right.
That is correct.
All right. I will amend that to a no violent contact with Clinton Sumlin, and not only to undergo an MHET, but also to be compliant with any ongoing MH treatment and medication.
Thank you, Your Honor.
Mr. Jordan, you can go ahead and mute Galaxy 12, please. Thank you. Ms. Deputy Milton, if we can unmute ACDC. And Ms. Folk, what is the recommendation for Ms. Price?
Yes, Your Honor. The state's recommendation is 12 months, served 36 days, credit for time served 18 days. That's going to be from July 1st, 2024 to today. Balance probated, no further violent contact with Clinton Sumlin. We are going to remove the stay away since they do reside in the same location. Family Violence Intervention Program, MHET, and comply with any prescribed medications.
And Ms. McLeod, based on this revised offer, does the defense stipulate to the factual basis, venue, and ID?
We do, Your Honor. And I would ask the court if it's possible after my client has completed the requirements with the FAIP and the MHET, if her probation could go non-reporting.
Any objection?
No objection.
Okay. Ms. Price, may I place you under oath? Please raise your right hand. And Deputy Milton, you'll need to unmute ACDC. Thank you. Ms. Price, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, you need to speak a little louder, okay? Have you consumed any medicine or alcohol recently? You can put your hand down.
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am, I am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
You understand that if you plead guilty to this charge, you would have to give up your constitutional right to a trial. You will not get the opportunity to confront your accuser, challenge the evidence brought against you, present your own defenses, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery family violence?
Guilty.
Your sentence is 12 months to serve 36 days, credit for time served 18 days. You'll be placed on probation. You report to probation on Monday, which will be the 22nd of July, and you must report to probation before 3 p.m. Probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a domestic violence intervention program, and you must enroll in that program within 30 days of being released. And you are also to visit your healthcare provider and go through a MH evaluation and submit to any treatment that's required. If you have ongoing MH treatment, you must be compliant with all treatment requirements and be compliant with all your medication. You may have no violent contact with Clinton Sumlin, and you may continue to have contact with him. No illegal drugs, no alcohol, and no weapons and no firearms. Understood?
Yes, ma'am.
That is the conclusion of your case. Thank you. Oh, and if you complete your domestic violence intervention program and the initial MH evaluation, then your probation may be non-reporting.
Yes, ma'am.
Thank you.
Thank you.
Thank you, Your Honor.
Next, we could go to position number 32, Mr. Ivory.
That's a negotiated plea, Your Honor.
Okay. This is State versus Tyrone Ivory, accused of theft by shoplifting from June 20th, 2024. Mr. Ivory has been advised of his right to remain silent, and his attorney is Mr. McLean. Mr. Ivory, please raise your right hand to be placed under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
You need to speak up.
Yes.
Thank you. Ms. Falk, is the state willing to go forward with the plea offer, considering that this charge qualifies as a felony?
Yes, Your Honor, we are ready to proceed. Let me just check something because I'm not sure if this would meet the statutory minimum on even the third.
NOLOs. Okay. All right.
Well, Your Honor, even if it's two NOLOs are now, they amended the theft by shoplifting recidivist to allow for NOLOs to count toward the felony. So that is not the issue. I'm willing to adhere to our agreement. I just want to make sure that the agreement actually reaches the minimum that would be allowed if it was a third theft by shoplifting. So we're willing to treat it like a third and not a fourth, but I don't even know if the recommendation meets the context for the third. So let me just double check something. Okay, it's not less than 30 days confinement. So yes, that would be fine. He meets the minimum requirements. All right, so the recommendation is 12 months, serve 32 days, credit for time served 16 days, balance probated, stay away from the Fulton Beverage Center located at 4401 Fulton Industrial Boulevard, South Fulton, anti-theft course, and a $500 fine. We would like the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For those purposes, we do.
Okay. Mr. Ivory, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And have you spoken with your attorney and still moving forward to enter a guilty plea to this theft by shoplifting charge?
Yes, ma'am.
If I accept your plea, this will be your 5th theft by shoplifting conviction since 2015.
Yes, ma'am.
All right. And right now, the state is willing to consider this as a misdemeanor charge. Any future arrest, you run the risk of it being automatically a felony charge. Do you understand?
Yes, ma'am.
All right. So are you still willing to move forward?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of theft by shoplifting?
Yes.
I accept your guilty plea. Your sentence is 12 months to serve 32 days, credit for time served 16 days. The remainder of the time you'll be on probation. You will report to probation on Monday, July 22nd, before 3 p.m. The probation office, do you know where it is?
No, ma'am.
It's at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll in an anti-theft class.
Yes, ma'am.
You must enroll in that class within 60 days of being released. That means by your third probation visit, you must confirm that you are enrolled in that class. You must also pay a $500 fine. By your second probation visit, you must pay a minimum of $50. And every month you must pay a minimum of $50, including your probation fees. Failure to do so will authorize probation to revoke probation and have you serve out the rest of the year at the Fulton County Jail. At all times, you have to stay. At all times, you have to stay 200 yards away from the Beverage Center store located at 4401 Fulton Industrial Boulevard in South Fulton. If you return to that location, you will be arrested again, which will give us grounds to revoke your probation. Any questions? Okay.
Any questions for the court? Thank you. Excuse me. Thanks.
Deputy Milton, do you have
We have position number 21.
anyone? Okay.
21, Mr. Galvin.
All right, Mr. Moises Galvin. Mr. Moises Galvin is accused of theft by shoplifting under accusation 24 CR 4434J. Mr. Galvin's got a second case, 23 CR 4898J, in which he's accused of, well, I can't tell from here. Was it theft by shoplifting and possession of drug-related objects?
That is correct, Your Honor. It was criminal trespass was the count 1 charge, and then the count 2 charge was possession of drug-related objects.
Okay, I've got a count 3 on this.
That was in error, Your Honor. It is only 2 counts. There
right.
was an original 3rd count, but it was NOD'd.
Okay. Mr. Galvin, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, with regards to both cases, how are we proceeding?
Guilty, Your Honor, on both.
Okay. Mr. Galvin, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what is the recommendation for both cases?
On the theft by shoplifting, Your Honor, the state's recommendation is 12 months served 2 days, credit for time served 1 day from July 6th, 2024 until today. Balance probated, stay away from Uptown Cheapskate, a store located at 1425 Market Boulevard in Roswell. Anti-theft course, 40 hours community service, and a $500 fine. On the on the add-on case, the state's recommendation on that is going to be 12 months concurrent to 24 CR 004434J. Stay away from Chevron, located at 1105 Holcomb Bridge Road. Count 2, drug objects, 4 days, credit for time served 2 days, 8/9 to 8/10 of 2023, and that will close out count 2. We're asking for the balance to be probated on the second case just to run it concurrent with the theft by shoplifting. We understand there are no additional requirements, but we would like to run the 2 concurrent.
Okay. Mr. McLean, does your client accept, and do you so stipulate?
He does, Your Honor. We do so stipulate.
And does Mr. Galvin have any other holds besides these 2 cases?
Let's see, do we have his 3 card handy?
Yes.
Galvin. I think I wrote it down already. Yeah. Your Honor, he has a methamphetamine case that only has, looks like $100 bond.
He, well, actually has a $200 total bond on the possession and use of drug-related objects, possession of methamphetamine under 24 PI 004711. Then he has a no bond on his felony theft by shoplifting case under 24 PI 003250. It's not a recidivist theft by shoplifting, Your Honor. It's just a over $500 theft by shoplifting.
Correct.
All right, just
So
want,
he's
That's what he's got.
right. This case actually wasn't holding him at all. Your Honor granted him an SOB through the jail the last time he was here in court.
all right. So I just wanted to be sure with regards to probation reporting requirements. Mr. Galvin, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings with regards to your current cases in state court and the case in Superior Court?
Yes, ma'am.
And are you still willing to move forward with the plea today?
Yes, ma'am.
Are you satisfied with the legal services you've received?
Yes, ma'am.
And if you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get a chance to confront your accusers, to be able to challenge the evidence brought before you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to theft by shoplifting at the Uptown Cheapskate?
Guilty.
And how do you plead to criminal trespass at the Chevron gas station in possession of a drug-related object?
Guilty.
On the theft by shoplifting, your sentence is going to be 12 months to serve 2 days, credit for time served 1 day, balance probated. Once you have resolved all your holds, you're required to report to Fulton County Probation on the first available business day at 132 Mitchell Street in downtown Atlanta, at which time your probation will begin. Within 30 days of being released, you will enroll in an anti-theft class. And by your second probation visit, you must show proof that you have enrolled in such a class. You are also to complete 40 hours of voluntary community service with a minimum of 10 hours every month within 30 days of being released. You're also to pay a $500 fine with a minimum payment of $50 every 30 days while you're on probation. With regards to this, and also, of course, stay away from the Uptown Cheapskate at 1425 Market Boulevard in Roswell, Georgia. With regard to the second case, 23 CR 4898J, on the trespass, your sentence is 12 months concurrent with count 1 of the previous case. You'll be on probation, and you are required to stay away from the Chevron gas station at 1105 Holcomb Bridge Road in Roswell, Georgia. And count 3, I guess, the possession of drug objects, that will be also concurrent to count 1.
Your Honor, I almost feel compelled for the record. We hate to have a person make themselves look bad for an upcoming shoplifting case in a different court, but regardless of advice of counsel, with full knowledge of the imagery involved, this is the course he wants to take.
Understood. Thank you.
I had a question.
Yes, Mr. Galvin.
So when would I be released?
You will be released after Superior Court has addressed your felony charges. This is state court.
We don't find Superior Court.
That's not correct.
I don't have the dates for Superior Court.
All right. Thank you. Thank you.
Good to meet you.
Your Honor, we have 2 of Ms. McLeod's clients in. If you could do your speech again. I brought in 2 different defendants.
I'm sorry, I can't hear you. You have 2 of Ms. McLeod's clients. Is Ms. Marie McLeod still on Zoom?
Yes, Your Honor, I am.
Okay, and what do we want to do with them?
It's a new group.
It's a new group. Okay.
I'm sorry, I did not hear what you said, Your Honor.
I think she said she brought in a new group of individuals, so they need to be advised of their rights. For the individuals who are just brought into courtroom 2, this is the misdemeanor all-purpose calendar in order to determine how you would like to move forward with your cases that are open and active. Please remember that you have a right to remain silent Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, one will be appointed to represent you. All right, Deputy in courtroom 2, who would you like to call next?
Position 23 through 26, Mr. Quintavious Green.
And Ms. McLeod, is that your client, Quintavious Green? Or is that Mr. McLean's?
Who do we have for you?
I believe that would be Mr. McLean's client, Your Honor.
All right, thank you.
Mr. McLean.
Let me take a look.
It says he's a conflict attorney.
Nobody informed me.
That's
I don't know that he's been assigned a conflict attorney yet.
Right, I don't believe so.
This is Quintavious Green.
Your Honor, we requested a conflict attorney a couple of days ago because we do represent the alleged victim in this case on a felony matter where Mr. Green is the alleged victim. So the PD's office really can't represent him, but I don't think I received a response whether one was assigned.
All right, Ms. McLeod, may I appoint you to Mr. Green's case? He has 1, 2, 3, 4 cases, ranging from, I have a December 3rd, 2022 battery, July 1st, 2024, 2 counts of simple battery, May 12th, 2024 battery, and March 22nd, 2020 simple battery. There are plea offers in the present case, but I highly recommend that he speak with you before moving forward.
Yes, Your Honor, I'd be happy to speak with him.
Okay. I will reset all 4 cases to July 25th.
Yes, Your Honor, that would be appropriate because I would need a chance to look at the discovery in the case and to speak with him.
Mr. Quintavious Green, you've been advised of your right to remain silent, and you've also been advised of your right to appointed counsel. It appears that the Public Defender's Office is unable to represent you since they already represent a defendant in a particular case in which you are apparently the victim. So they are unable to represent you pursuant to a conflict of interest. Do you understand, sir? You need to respond yes or no.
Say yes.
Okay. In light of the conflict, I will be appointing attorney Maureen McLeod, as you see her on the screen, and she would need an opportunity and time to speak with you so that she can give you her professional opinion with regards to any recommendations in your case. So your 4 cases are going to be reset to July 25th so that Ms. McLeod will have time to speak with you and decide your next course of action. Thank you.
That will also go for position number 27, Your Honor, Noah Green.
Yes. And Ms. Vigilante or Mr. McLean, same announcement?
I believe so.
Okay. Mr. Noah Green, please remember that you've been advised of your right to remain silent, and your attorney, unfortunately, would have to be changed to a conflict counsel. Ms. McLeod, may I appoint you to represent Mr. Noah Green?
Yes, Your Honor.
All right. I first want to clarify. Mr. Noah Green, do you know, or is your case in any way related to Quintavious Orlando Green, the individual I just addressed?
No.
Okay, so it's just a coincidence you have the same last name.
Yeah, but mine is the E on the end. His is regular, like the
Yours
color.
has a silent E at the end. Noted. All right. So as the Public Defender's Office is unable to represent you due to a conflict of interest, I will have Ms. McLeod represent you, and she will need an opportunity to speak with you and understand all the circumstances of your case so that she can give you a professional recommendation. I will reset your case to July 25th so that she may confer with you, and then both of you can decide how you would like to move on. Do you understand?
Yes, ma'am.
All right, thank you, sir.
Your Honor, I believe that concludes my business before the court today.
If you believe so, then I definitely will release you. Thank you, Ms. McLeod.
I was unaware of Miss Price, but I was just lingering because I was doing something else.
Okay, I appreciate it. Thank you. Okay.
Your Honor, I just want to make sure that Ms. McLeod is not on any of our 11 o'clock cases.
Are you on any of the competency cases?
I am.
I'm going to pull it up right now.
I have 10 o'clock, but it's not with you, Judge Lau.
Okay.
Okay.
I don't see a Hambrick and King. Does that ring a bell?
No, Your Honor. Those are not my plans.
Okay, then we're good. Thank you, Ms. McLeod. We'll see you later.
Thank you.
All right, ACDC, who do you have next?
Your Honor, I believe there might be Hoda Atai's client's position 44 and 45. And then I have a probation one, position 1, Ms. Smith. And then I need the breakout with the Spanish interpreter.
Okay. Courtroom 2, please hold. All right, position, she said 44, Kimberly Parks. Is that your client, Ms. Atay?
Yes, Your Honor.
Okay, and how are we proceeding in that case?
That's a negotiated plea.
Okay, you can have a seat, Ms. Atay. It's
Okay.
I know the video is a little off on courtroom 2, and unless you're seated, I'll only be able to see you from neck up. So, okay, there you go. Thank you. So Kimberly Parks is at ACDC. Ms. Parks, my name is Judge Law. You've been advised of your right to remain silent, and your appointed counsel is Ms. Hoda Atay. Do you see her in courtroom 2?
Yes, ma'am.
All right. The case before us is 21 CR 64678, in which you are accused of driving under the influence of alcohol less safe, driving under the influence of alcohol per se, and failure to dim lights. Position 45 is a bench warrant, 24 FTA 863. This is going to be a negotiated plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation for Ms. Parks?
Yes, Your Honor. The state's recommendation is 12 months on the DUI. And actually, the way that we did this was accidental. We should have merged count 1 into count 2. And so for count 2, the recommendation is 12 months, serve 32 days, credit for time served 16 days, March 14th, 2022 to March 15th, 2022, July 5th, 2024 to today, balance probated, ADET, DUI risk reduction course, victim impact panel, $300 fine, 40 hours of community service. As I stated, that's on count 2. Count 1 merges into count 2, and count 3, failure to dim lights, would be 12 months probation concurrent with count 1 and a $265 fine.
Ms. Atay, does your client accept these terms, and do you so stipulate?
Yes, I do so stipulate, and she does accept those terms.
Thank you. Ms. Parks, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to enter a guilty plea to 2 counts, you would have to give up your constitutional right to a trial before a judge or a jury. You will not get the opportunity to go back to court, confront your accuser, challenge the evidence brought before you, have the assistance of counsel to present your own defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, yes, ma'am.
How do you plead to 1 count of DUI, driving under the influence of alcohol per se, and 1 count of failure to dim lights?
Guilty.
Count 1, driving under the influence of alcohol less safe, merges into count 2. The sentence for count 2, DUI per se, is 12 months to serve 32 days, credit for time served 16 days. Your jail time is concluded, and once you're released within 24 hours, you will be placed on probation. You will report to the Fulton County Probation Office next Monday, July 22nd, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a DUI risk reduction program. And that class must be enrolled within 45 days of being released. You will also submit to an alcohol and drug evaluation and submit yourself to any treatment as required, and that must be done within 30 days of being released. You will attend and complete a victim impact panel in accordance with probation schedule. You will pay a $300 fine and complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin your community service with a minimum of 5 hours per month and 5 hours minimum every month thereafter. You will report to probation every month until the conclusion of the 12 months. With regards to count 3 on the failure to dim lights is going to be 12 months concurrent with count 1 and an additional $265 fine. That concludes your sentence. Thank you.
And Your
Oh.
Honor, the state is entering a null pros in position 45.
Yes, the bench warrant will be dismissed. Thank you. And then, Ms. Ate, you had another client at ACDC?
Yes, that I need to interview with with Miss Chansey.
Okay, and who was the third? There were 2 other cases, Ms. Deputy Milton. So it was the Spanish interpreter case, and who's the other one?
Probation revocation 1.
All right.
Latanya Smith.
Let me take probation revocation. I believe that's the only case on the calendar. This is Natanya Nishan Smith, case number 18 CR 6493D. Ms. Smith, you have been convicted of battery causing substantial physical harm and battery family violence. There was apparently a probation violation, and there is a warrant to revoke your probation. Who's my probation officer this morning? Miss Allen? Mrs. Allen?
My apologies, Your Honor. Good morning. I'm here.
Good morning. Thank you. May I place you under oath, please?
Yes, ma'am.
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, Your Honor.
All right. Ms. Smith, our probation officer, Ms. Allen, is going to let me know the reasons why they're seeking a revocation and what is the recommendation. Please remember that you've been advised of your right to remain silent, and your attorney is Ms. Atay. Ms. Allen?
Yes, Your Honor. I'm sorry, Your Honor. This is Officer Brooks. This isn't Officer Allen.
I beg your pardon, Officer Brooks. Yes, I'm still going to deem you to be under oath. So.
Okay, thank you, Your Honor. We're here for Natanya Smith. She was seen back on April 15, 2019 for battery family violence. She was sentenced to 12 months probation to complete domestic violence intervention program.
I'm sorry, Ms. Brooks, I think your Wi-Fi is just frozen. Oops. All right. Ms.
No.
Brooks, I'm so sorry, Wi-Fi froze and you were left off as where she failed to complete the DVIP. Oh. Let me see.
Of $480. She failed to report on July 11th, August 20th, and September the 6th of 2019. She has 109.
Oh. Let's see if we can send her a chat. Officer Brooks, your Wi-Fi is frozen and we could only hear bits of what you were saying. Could you stop your video and just leave it on audio? That may assist. Okay. Can you hear me all right? Officer Brooks, can you hear me? All right. We may have to take the revocation matter up. Officer Brooks, you may have to leave the Zoom. All right, it's still frozen. Miss Allen, Mr. Officer Brooks, if you can hear me, you probably have to leave the Zoom and re-enter. Your Wi-Fi is not stable. Okay. Deputy Milton, we're gonna have to hold off on Miss Smith until Officer Brooks' Zoom is in working condition. So who needs to speak to the Spanish interpreter case?
I do.
All right. Mr. Tay, do you have a separate Zoom panel that I can place you in a?
Yes, I need to get back on that. And that's for interviewing the client at ACDC.
That would be correct. And is that your probation? Is a probation your client as well?
Yes, it is.
Okay. Ms. Chansey, we're going to place you in a separate breakout with ACDC. I'm
Yes,
sorry, I
ma'am.
didn't catch the name of the individual. All right. Mr. Jordan, if you could please place Ms. Hoda, Fulton, ACDC, and Ms. Chansey in a breakout, please. And then Ms. Chansey will address all the matters. Alpharetta, if you could please hold. As soon as our interpreter is available again, we will proceed with the Alpharetta case. Courtroom 2, do you have another case to address?
Yes, Your Honor, this is a new group, so they will have to be read their rights.
All right. For the individuals who are in courtroom 2, we are continuing to address your open active misdemeanor cases with the State Court of Fulton County. My name is Judge Law, and today with your counsel, you are going to indicate how you would like to move forward with your cases, either accept a plea recommendation from the state or enter a not guilty plea. In that light, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and one, if you cannot afford one, one will be appointed to represent you. All right, the first case in courtroom 2, please.
Position 5 and 6, Mr. Brandon Brown.
This is State versus Brandon Keith Brown. Mr. Brown, you have one active case, 23 CR 3485E, in which you've got a charge of which Ms. Vigilante, your attorney, is going to show you. And that's a misdemeanor offense. You have been advised of your right to remain silent, and your attorney is Ms. Vigilante. Ms. Vigilante, how would you like to proceed? His second case is a bench warrant, 24 FTA 872.
Yes, Your Honor, the bench warrant is what's holding Mr. Allen in custody. I've just sent you, I'm sorry, Mr. Brown in custody. I've just sent you the proof that I have, showing that he was in Muskogee County Jail when he was in court.
Oh. What's going on? Ms. Falk, did courtroom 2 just freeze as well?
It does appear so, Your Honor. Not sure what exactly happened.
All right, Ms.
I'm sure it's
All right, Ms. Vigilante, I'm so sorry. You said that you sent an email. Did you send one to Ms. Falk as well?
Yes, Judge,
Oh dear. I think that this may be a. All right, Ms. Vigilante, I do apologize, but the Wi-Fi is not stable. You are freezing up. All right, let's try this again. So let me look at the Officer Brooks, please hold. We are still waiting for probation to come back, okay? Officer, Ms. Falk? I'm just trying to, Ms. Vigiletti, can you hear me? Ms. Shelley Falk, can you hear me? All right, it might be me. I'm gonna, Mr. Jordan, I'm going to leave the Zoom and come back in just to make sure that it's not me, because it seems to be freezing up. All right, Ms. Vigiletti, can you hear me?
I can hear you. How about me?
Yes, loud and clear. So I saw your request to the Muskogee Sheriff's Office, and what were you trying to tell me?
Yes, I'm sorry, I realized I sent you both the wrong document, as soon as I sent it, so I just followed up with an additional document. What I have just sent you is the publicly available document related to Mr. that shows, he was sentenced to 180 days in jail last February, so he would be in custody, when he missed court in July. I did reach out and request more formal proof because I did speak with Muskogee County Jail this morning to ask them, how can we get more formal proof than just this public document? They had me send them a request. I did send that request. I haven't gotten a more formal certified proof of Mr. Brown's incarceration back yet, but I do expect to get that today. I did speak with them.
And perhaps I missed something. I'm not seeing the public document. All I received was a letter making a request.
I sent a follow-up email at 10:11 a.m. Did you not get a follow-up email?
I did not. My last email from you is at 10:10.
Let me send a new one. I'm just gonna send a new one altogether to you both because we are having internet issues here.
Totally understand.
Okay, I just sent a completely separate email. And it is a long document. When you get it on page 3, it shows the sentence, which was on February 8th to 180 days of confinement.
Give me that date again.
February 8th, 2023. And Mr. Brown missed court on July 19th last year.
So he's got a failure to appear here, and he's still has a Muskogee County hold.
He does. He has an additional matter to address, a probation issue in Muskogee County. And so he will, when he leaves here, go to Muskogee.
Right. Ms. Falk? I'm sorry, Ms. Fault, I'm assuming you're just reading the document.
Yes, Your
Okay.
Honor, I saw a note that kind of, I'm trying to wrap my head around toward the bottom. So I was looking at that. Now I'm looking at the, his date that he failed to appear.
Mhm.
And so that's what I'm trying to get a grasp on. Because I'm not seeing when his failure to appear was.
I don't see it either, but it appears to be July 19th, 2023, and he's got no bond. Let me see.
Okay.
Okay.
Well, July 19th, 2023.
So
Okay. And
he had $1,000 surety bond. Are you
no,
sure
I
it's
see
not
that.
in his Superior Court case, Miss Vigiletti? He's got a aggravated strangulation case there. So
I'm sorry, am I sure of what?
June 15th, 2023 was an order for bond. He got a UJR on June 15th, 2023. This was for some reason it was signed off by Judge Edwards in Superior Court. I'm not certain he's got a bench warrant in the state court case, but he does have a bench warrant in
Oh, okay. I
I
think I've gotten to the bottom of this, everyone.
Okay.
So the FTA was from pretrial services for him failing to appear at pretrial services. And it was
Okay.
signed by Judge Morrow on May 1st, 2024. So I don't think his incarceration in another county in 2023 has absolutely anything to do with this. It's him not showing up to pretrial services that led them to then issue a bench warrant, which Judge Morrow signed in May.
And probably due to the arrest in Muskogee County.
I'm not sure what the basis was. It just says pretrial services failure to appear, warrant, and signed by Judge Morrow on May 1st.
Okay.
Transfer from here to Muskogee when they gave me that position bond.
So what are you asking, Miss Vigiletti?
Yes, I understand, Your Honor. Mr. Brown was in custody the vast majority of 2023. If Your Honor would consider giving him another shot at a pretrial services bond on this, he is confident he can resolve his Muskogee issue fairly quickly. He knows exactly what it is. And it's a violation of probation, he says, and can get that together. I do have an address for him. So I do think he would be able to stay in touch with the court, if you would consider another shot at a pretrial services.
I would consider another shot, except look at this, November 2017, parole violation and escape. Booked in on July 3rd, 2019, he had a foreign county hold. All booked on June 27, 2020, failure to appear for his escape charge with a foreign county hold. Then in May 31st, 2023, booked in for a failure to appear. And now, of course, booked in on June 29th, 2024 for failure to appear. Mr. Brown seems to be rather preoccupied in other jurisdictions. I think I'd like him to have a vested interest in making sure he shows up in court. We're going to maintain the same no bond. Well, no, I'm going to put a $5,000 surety bond.
Understood, Your Honor.
So what she want to do today?
If I may, Judge, have a moment to speak with him, we only discussed the bench warrant, and it might be possible that Mr. Brown is interested in a plea offer today if you're willing to consider.
Whatever you'd like to consider, that's perfectly fine. But right now it's a $5,000 surety bond on the bench warrant, and we'll take it up. So moving on. Thank you.
Okay, thank you, Judge.
Okay, Miss iPhone, who do we have?
Position number 50, Tillman.
Tillman.
Oh, they were.
There she is, the big T.
I'm sorry about that. Position 50. This is Demetrius Tillman. Case number 24 CR 4412G, who's appearing at the jail court iPhone. Mr. Tillman, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is it Ms. Ate?
Yes, Your Honor.
Okay. Mr. Tillman was cited with failure to obey traffic sign, willful obstruction of a law enforcement officer, and driving while license suspended or revoked. Yes, how would we like to proceed?
Yes, Your Honor, with a not guilty plea, I will file the waiver of arraignment, and I would like to make a bond argument.
Please proceed. Please proceed, Ms. Ate.
Oh, okay. Yes, Your Honor, my client has lived in Georgia all his life. He is the father to a 1-year-old and a 14-year-old child. He has been working as a tattoo artist for the last 19 years. He has his GED. He has a mailing address in Woodstock, Georgia. He's being held here on a probation violation. He was supposed to have a hearing on July 6th. That's a 10-year-old felony case. He stated that they didn't take him to the probation hearing on July 6th, so he's still waiting for that. And other than that, he's held on a driving while license suspended, $2,000 surety bond. And I would just ask for I think the other charges were set.
A signature bond to the jail. I believe he's got not only the felony matters from 2022, but he's also got prior suspension matters. So
he's held on the 24 CR 004412G, a $2,000 surety bond. I think it's the same. I mean, I'm not sure, but I would just ask for a signature bond either through the jail or pretrial services on that charge.
Your Honor, if I may.
You may.
Your Honor signed this bond on July 5th of 2024. And the basis for Your Honor's grant of a $4,000 split bond, which was $2,000 on the failure to obey traffic sign, willful obstruction of law enforcement, and then a $2,000 surety bond on the driving while license suspended. Your Honor was thorough enough to put the basis next to the $2,000 surety bond, and the court was 2021 and 2017 incidents for driving while license revoked and suspended. That does correspond to his criminal history, which shows that he was convicted in 2021 out of Snellville Municipal Court for driving while license suspended, and had been previously convicted of driving while license suspended in 2017. So that was the basis for Your Honor granting a $2,000 surety bond on this case. That driving while license suspended in 2017 was out of Cobb and was accompanied by a driving without a valid license and possession of marijuana less than 1 ounce. The defendant also has failure to appears, as well as looks like a Fulton County Superior Court case 18 SC 160833, where he was serving a 5-serve 1 sentence for possession of a firearm, either by a first offender probation or a convicted felon. It has a lot of language there. And a 2014 possession of or sale of marijuana, distribution of marijuana, which is the case he currently has the violation on. He also has a failure to appear from 2018 out of Cobb County, as well as, I think I did see another failure to appear, a probation violation out of 2022 from Snellville, a different probation violation out of 2022 from Fulton County, and a failure to appear in June of 2023.
Ms. Falk, that's plenty.
Yes,
Ms.
Your Honor.
Ate, this, yeah, Ms. Falk is correct. I went through his calendar, I mean, his GCIC, and that just isn't insufficient grounds to grant a signature bond for Mr. Tillman with this significant history.
I understand, Your Honor. He has spent 15 days in custody.
Well, he has to decide what he wants to do, bond out or to take this matter up and take this matter up for trial. Well, at the present time, he's entered a not guilty plea, so the case will be further noticed for trial. This could easily have been a $4,000 surety bond.
I understand. Thank you, Your Honor. I'll file the waiver of arraignment.
Thank you. All right, moving on to Miss Officer Brooks. Miss Smith, if you could come back to the screen, please. Officer Brooks.
Your Honor, my apologies. I'm back. Miss Brooks was having issues with her camera.
All right, Miss Allen, then, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide is the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right, Miss Smith, have a seat. Don't worry. You just come and have a seat at the computer. Thank you. And Deputy Milton. Deputy Milton, would you please come and unmute the screen? And Ms. Ate, have you concluded your interview with the person at ACDC as well with Ms. Chansey?
Yes, Your Honor.
All right.
Your Honor.
All right, thank you. We are continuing with the probation revocation case with Nashawn Smith. And Ms. Allen, unfortunately, we were unable to hear the reasons and the recommendation from probation. Could you please let us know?
Your Honor, the defendant was charged with a charge of battery family violence. She was ordered to complete 12 months probation, complete domestic violence counseling, no contact with the victim in the case. Your Honor, she has failed to provide our office with the completion of the domestic violence course. She's failed to report to our office. It's 196 days remaining on her case. Your Honor, that will be enough time for her to complete the domestic violence program, so we ask that she be allowed to continue on probation.
All right, thank you. Ms. Ate?
And I have no objection to that, Your Honor. She can complete the DVIP in the next 196 days. She is 45 years old, has lived in Georgia all her life. She's the mother of 7 children, including 3 minor children. Of course, this is old, 5 years ago, so they were a lot younger at that time. She does run a business, a cleaning business here in Georgia. Yes, I have no objection to the probation officer's recommendation.
This will be recorded as a probation violation in this case. Ms. Smith will continue on probation. She will report to probation. Today is Thursday, so she'll report on Monday, July 22nd, before 3 p.m. She will report every 2 weeks, not just once a month. She will report every 2 weeks. That's twice a month. And she will need to be enrolled in a DVIP program. within 30 days of being released, and she will continue to attend all classes and report to probation every time she visits that she is continuing to attend. Failure to complete the program or if she misses any of the classes, even one class, if she misses one class, that is sufficient grounds for probation to revoke and to have her serve out the rest of the 196 days or what is the remainder in Fulton County Jail. So Ms. Smith, please understand it's not once a month, it's twice a month reporting to probation, and you must enroll within 30 days and complete all 24 weeks of these classes at your expense. Thank you.
Yes, ma'am. Thank you.
Your Honor, that concludes my business. May I be excused?
Yes, thank you, Ms. Allen. Appreciate it.
Thank you.
All right, Ms. Tay, you have, yes. Chansey?
Oh, I have a dozen people. Which person is on?
Ms. Chansey? Yes, good morning. Do you solemnly swear and affirm the information you translate will be a true and accurate translation with no changes or embellishments?
I do, Your Honor.
Thank you.
You're welcome.
Okay, who's your client at ACDC?
Thank you.
It is Pablos Valladares.
Valladares, okay. And I'm just trying to see the position number.
52.
All right, 52 and 53, okay. This is State versus Pablos Valladares, accused of possession and use of a drug-related object, loitering and prowling, and he has a bench warrant as well.
Este es el caso de la Fiscalía contra Pablos Valladares, acusado de uso de objetos relacionados con el uso de la droga y también por merodear y vagabundear. That's it.
His case numbers are 22 CR 4571E and 24 FTA 826.
El número de caso, los casos son 22CR004571E y 24CRFTA00826.
And Mr. Valladares, you have a right to remain silent about the facts of the case. Anything you say can and will be used against you. You have a right to an attorney. If you cannot afford one, Mr. Tay will represent you.
Usted, señor Valladares, tiene el derecho a guardar silencio. Todo lo que diga acerca de los hechos de su caso pueden y serán usados en su contra. Usted tiene derecho a tener un abogado y la señorita o señora Jara lo está representando.
Mr. Tay, how are we proceeding in this case?
Your Honor, he wishes to plead not guilty on position 52, but and that case isn't holding him here, Your Honor. And I do want to address position 53, the FTA.
Bueno, él es una declaración de inocente en la posición 52 que está pendiente, pero sí quisiera dirigirme a usted para hablar sobre la posición 53.
Mr. Valladares, your attorney will be entering a not guilty plea on your behalf, and your case is going to be rescheduled for trial. In the meantime, we will address your bench warrant.
Señor Valladares, usted, su abogada está dando una declaración de inocente de su parte, entonces para que esto se vuelva a tener otra cita para ir a juicio. Mientras tanto, vamos a dirigirnos hacia el cargo de que emitió una orden de arresto.
Ms. Ate?
Yes, Your Honor, for position 53, the FTA, I looked in Odyssey and there is a return to sender for the notice for that court date. It was mailed to residentially challenged Atlanta, Georgia, 30350. You can't call that an attempt to notify him of his court date. That's not an address.
En la posición 53, por la falta de comparecencia, se emitió una residencia como un intento en Atlanta, Georgia, a un código postal del 30351. Uno no puede hacer un intento, sino debe enviarse a una dirección directamente.
Miss Atay, the bond seems to have been set by Superior Court.
Parece que esta fianza fue emitida por el Tribunal Superior.
I'm not sure where there's a $1,000 surety bond on robbery, 500 on battery, 500 on willful obstruction.
Yes, there's a $2,000 cash bond on a failure to appear.
No estoy segura porque hay una fianza de $1,000 bajo garantía por robo, también $500 por golpes y lesiones y $500 por obstrucción. Sí, también hay hay por falta de comparecencia.
Was that issued by state court?
Fue emitida por la Corte Estatal.
I believe so. It's on the calendar, position 53. I believe my laptop.
Creo que sí, está en la posición 53.
All right. Ms. Falk?
Señora Falk?
Yes, Your Honor. There are two things. This was issued by Judge Morrison on March 20th, 2024. The defendant had failed to update his address as required by the court. Additionally, on June...
1 second, please. I'm just going to make that.
Sí, su señoría, hay dos temas. El primero, que esto fue emitido por la jueza Morrison el 20 de marzo del 2024, debido a que el acusado no había actualizado su dirección. Please go ahead.
Go ahead.
Additionally, Your Honor, on June 7th of 2023, the PD's office filed a entry of appearance on behalf of Mr. Vallartes. And apparently, when the attorney was in court at the time that the bench warrant was issued, I'm not sure if they had any contact with him at that point because a bench warrant was in fact issued for his arrest.
Bueno, adicionalmente, el 7 de junio del 2023, en el Departamento de Policía se registró este caso del señor Pablo Valladares por el abogado, pero en realidad la orden de arresto no se había hecho contacto con él y cuando la orden de arresto se emitió.
The defendant then came back to court came back into custody on May 24th, 2024 on the new charges of robbery, battery, and willful obstruction of a law enforcement officer.
Okay.
El acusado regresó bajo custodia el 4 de mayo del 2024 debido a todos esos cargos ya mencionados.
Additionally, there is a hold from Roswell PD.
También hay otra detención de la policía de Roswell.
Okay. Ms. Atay, anything else?
Señora Satay, ¿algo más?
Yes, Your Honor, I would just like to ask for the bench warrant to be lifted, or if just address the $2,000 cash bond on the failure to appear, if it can be converted to a signature bond, even if it's through free trial services, or simply lift that bench warrant.
También yo quisiera solicitarle que se saque esa orden de arresto por el cargo que lleva una fianza de $2,000 y que se convierta en una fianza bajo firma, ya sea a través de los servicios previos al juicio o por la cárcel.
Case is going to be scheduled for a jury trial, and the bond is going to be set at $500 on each count, and that's a surety bond to stay away from the incident location.
Este caso va a ser derivado a otra fecha para ir a juicio. Hay $500 de fianza para cada cargo con fianza bajo garantía y tiene que mantenerse totalmente distanciado del lugar del incidente.
Within 30 days of being released on his surety bond, he must update the court with his current mailing address in writing with the clerk's office.
Después tiene 30 días después de que salga bajo fianza, bajo garantía, y tiene 30 días después de salir para actualizar su dirección de residencia por escrito ante la Secretaría del Tribunal.
That concludes this hearing. Thank you.
Esto concluye la audiencia. Gracias.
Your Honor, what, are you setting a surety bond for position 52?
The bench warrant was for $2,000 cash. I'm amending it to $500 surety on each count. Or do you want me just to do a straight out 1,000 surety on the bench warrant?
Well, the bench warrant is a failure to appear. I don't know what's the second count.
I'm just going by the charges based on the bench warrant. So in that case, if that's what's holding in, then I'll amend the $2,000 cash bond to $1,000 surety. Is that how you want to have it done? I don't see the order from Judge Morrison on Odyssey. That's why I'm not certain how it was broken up.
Your Honor, I can send that over if it will assist the
I
court.
don't see it on Odyssey at all. Sorry, Ms. Chansey, his bond in order to be released is $1,000 surety. And then he'll need to make sure that he updates the court with his current mailing address. If you can convey that to him, that would be helpful.
Yes, ma'am. Señor, la fianza en realidad es enmendada, cambiada $1,000 bajo garantía o monetaria. Pero tiene que, una vez que salgas, tiene 30 días para usted llevar por escrito su nueva dirección de residencia. Tiene que actualizar al tribunal con su nueva dirección. Tiene 30 días.
All right, thank you.
You're welcome.
Alpharetta, who do we have, please? Deputy at the Alpharetta precinct, if you could please unmute.
That'll be position number 38, Your Honor.
Okay. Johnny Julian?
Yes.
Okay. And Ms. Atay, who represents Mr. Julian?
I do, Your Honor.
Okay. Ms. Chansey, you've already been sworn. This is State versus Johnny Julian, accused of 1 count of simple battery, 2 counts of battery, and a 4th count of criminal trespass.
Entonces, este es la fiscalía en contra del señor Johnny Julián con un cargo de golpes y lesiones simples, 2 cargos de golpes y lesiones y un cargo por allanamiento de morada.
Okay. Mr. Julian, you have a right to remain silent about the facts of the case. Anything you say can and will be used against you. You have a right to an attorney, and representing you today is Ms. Hoda Atay.
Señor Julián, usted tiene el derecho a guardar silencio. Todo lo que diga acerca de los hechos de este caso pueden y serán usados en su contra. Tiene derecho a tener un abogado que lo represente y en este caso lo representa la señora Hoda Atay.
On August 24th, 2022, you were released on a $9,000 signature bond through pretrial services with a stay away and no contact conditions.
Usted fue dado para ponerlo en libertad condiciones de mantenerse alejado y no tener contacto con la víctima y con una fianza de $9,000. Eso ocurrió el 24 de agosto del 2022.
On June 30th, 2024, you were arrested for new charges.
Y el 30 de junio del 2024 fue arrestado con nuevos cargos.
And your signature bond has been surrendered.
Entonces se ha quitado su posibilidad de tener una fianza bajo firma.
You currently have a $29,000 surety bond.
En este momento usted tiene una fianza de $29,000.
Based on your surrender of the signature bond.
Y basado en la negación de la fianza bajo firma.
And the new felony charges.
Y debido a los nuevos delitos mayores.
Ms. Ate, how would your client like to move forward?
¿Cómo quiere, señora Ate, que esto continúe?
A non-negotiated plea, Your Honor.
Right.
Queremos tener una declaración no negociada.
Mr. Julian, please raise your right hand.
Por favor, señor Julián, levante su mano derecha.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Señor, usted jura solemnemente que dirá toda la verdad y nada más que la verdad, lo mejor que usted pueda. I cannot hear.
Sí, lo juro.
Yes, I do.
All right. Ms. Falk, what's the recommendation for Mr. Julian?
Well,
Señora Fogg, ¿cuál es la recomendación para el señor Julián?
Your Honor, as this is a time served plea, I would like to know what part of this is non-negotiated.
Debido a que quisiera saber cuál es la parte de la declaración que no es negociable.
Your Honor, it has been homeless. Because of the no contact order, he has been residentially challenged for the last couple of years. I would like to ask for the balance of the probation either to be suspended or to not do the 12 weeks of anger management, which he wouldn't be able to afford. He could do the community service though.
Lo que él ha estado, no, o sea, no tiene residencia donde vivir y debido también al no poder tener contacto, ha tenido desafíos de obtener una residencia. Por eso solicito que se suspenda el balance y también el curso de manejo de la ira porque no va a poder pagarlo y podrá cumplir las horas de trabajo a favor de la comunidad.
Miss Ate, I'm sorry, Miss Falk.
Yes, Your Honor.
Time served, it looks like on battery, you're asking for probation after serving 52 days. So.
But he would receive credit for 26 days. When I said it was a time served, I meant the jail time. He would get out today if he did not have the other cases holding him.
I see.
But I'm ready to proceed.
Ms. Chansey, could you translate that?
Lo que estoy tratando de decir es que el tiempo servido fue para la parte del encarcelamiento del acusado. Si él no tuviese esos otros cargos, o sea, él podría estar fuera de la cárcel hoy.
So, Ms. Ate, because of poverty and homelessness, you're asking me to simply give him time served, balance suspended. Would that be correct?
Yes, Your
Entonces,
Honor.
señora Alzate, debido a la pobreza y al no tener un techo donde vivir, usted me está pidiendo que lo que se debe se suspenda y que también el curso de manejo de la ira. ¿Está correcto? Sí, su señoría.
And in the meantime, on June 30th, he's been arrested of this year. He's been arrested for 2 felony counts of obstruction of an officer, reckless driving, and battery.
One moment, please. Entonces, mientras tanto, el 30 de junio de este año, él obtiene cargos de delito mayor, que es obstrucción a la autoridad por manejo negligente. What was the last charge?
And 1 count of battery.
Oh, y un cargo de golpes y lesiones. Thank you.
But what I'm also being informed about is that Mr. Julian is unable to fulfill the conditions of the proposed plea in the event he does decide to accept the plea offer from the state.
Pero también he sido informada de que si él se declara culpable, el señor no podrá completar las condiciones que se le imponen si yo acepto su declaración.
He is able to complete the 40 hours of community service. And I mean, he could do the 12-week anger management. It's just that it would present a hardship for him to pay for that course.
Él podría cumplir con las 40 horas de trabajo a favor de la comunidad y también podría tomar el curso de 12 semanas de manejo de la ira, pero serían realmente algo muy difícil de realizarse financieramente.
I'm not accepting this plea offer then. I don't believe Mr. Johnny Julian will be able to comply with any of these proposed conditions, even if it's a hardship, given his new arrest.
Entonces yo no acepto su declaración de culpable hoy porque creo que él no va a poder cumplir con las condiciones que se le impongan para que esa declaración sea aceptada.
I will consider this as a not guilty plea and further notices for trial.
Voy a considerar esto como una declaración de inocente y le daré una cita para ir a juicio.
He wished to plead guilty.
All right, I can sentence him to up to 12 months.
Entonces, él desea declararse culpable. Bueno, entonces puedo hacerle una sentencia de 12 meses.
I don't believe, I'm exercising my discretion on the grounds that I don't believe Mr. Julian will comply and complete the conditions of the proposed plea offer.
Yo en realidad no creo, estoy usando mi discreción, mi análisis personal y no creo en que el señor Julián pueda cumplir con las condiciones necesarias.
He's presently also got a felony hold in Superior Court. If he resolves that hold, I'm sure we'll be able to address this case again.
Entonces, en este momento él tiene pendiente un caso de delito mayor con el Tribunal Superior. Si él resuelve ese caso, entonces podrá continuar con la resolución de este caso hoy.
Taking a plea offer today will not accelerate his release from jail.
Porque una declaración de culpabilidad hoy no va a hacer que se lo ponga en libertad más rápido.
Anything else, Ms. Sate?
¿Algo más, señora Sate?
Nothing further.
All right,
Nada
in that
más.
case, I will arraign the case. Would you like to file a waiver or would you like me to arraign the case?
I think it's better to arraign it while we have the benefit of a translator.
Yo quisiera que este caso se lleve a una información de cargos mientras tenemos a la intérprete.
Mr. Julian, I'm exercising my discretion and refusing to move forward with this plea offer as offered by the state because I don't believe you will be able to complete the conditions.
Señor Julián, yo estoy usando mi discernimiento y yo rechazo su declaración de culpabilidad ante la propuesta declaratoria del Estado, de la Fiscalía, porque yo no creo que usted tenga la capacidad de cumplir con las condiciones que se le impondrían.
Therefore, the only plea I'm accepting today is a not guilty plea, and I will arraign your case.
Entonces, yo voy a aceptar solamente su declaración de inocente y lo que será, se voy a leer los cargos.
You are charged with 1 count of simple battery, 2 counts of battery, and 1 count of criminal trespass from July 17, 2022 in Fulton County, Georgia.
Usted tiene un cargo de golpes y lesiones simples, 2 cargos de golpes y lesiones, un cargo por allanamiento de morada, ocurridos el 17 de julio del 2022 en el condado de Fulton, estado de Georgia.
This is a misdemeanor case involving 4 separate victims.
Este es un delito menor que involucraron a 4 víctimas individuales.
These are the 4 charges. Would you like me to read the details of those charges, or do you waive a reading of the details?
Estos son los 4 cargos y ¿quiere usted que se le lean detalladamente la información de cada uno o usted quiere renunciar a que se le lean todos los detalles de los 4 cargos?
Julian, that was a question to you. Would you
Esa fue una pregunta, señor.
Sí, quisiera saber los detalles.
¿Quisiera hacer qué, perdón?
Quisiera saber los detalles.
Yes, I would like to know the details.
On the accusation
En la acusación
regarding simple battery, the prosecutor charges Mr. Julian that on July 17th, 2022 in Fulton County,
entonces, la acusación dice que por golpes y lesiones simples, la Fiscalía acusa el día 17 de julio del 2022 en el condado de Fulton
did intentionally make physical contact of an insulting and provoking nature with Aurora Moreno.
Intencional contacto físico, insultante y ofensivo con Aurora Moreno.
By fighting in violation of Georgia law 16-523.
Peleando lo que es un incumplimiento de la ley del estado de Georgia 16523.
On count 2, with regards to battery.
Y el cargo 2, con respecto a golpes y lesiones.
The prosecutor charges the defendant with battery in that on July 17, 2022 in Fulton County.
La fiscalía acusa a este acusado con los siguientes cargos del día 17 de julio del 2022 en el condado de Fulton.
By intentionally causing bruises and scratch marks, visible body harm to Nestor Perez.
One moment, please. En esa fecha intencionalmente causó moretones y también rasguños físicos a la... It was Mr. Perez, Your Honor, Miss.
Nestor Perez.
Oh, Nestor. A Néstor Pérez.
By fighting him in violation of Georgia law 16-523.1.
Peleando, cometiendo el incumplimiento de la ley de Georgia 16523.
On count 3, with regards to the battery charge.
Con respecto a el segundo cargo de golpes y lesiones, que es el cargo 3,
also on July 17, 2022 in Fulton County,
también el 17 de julio del 2023 en el condado de Fulton,
the prosecutor accuses defendant of intentionally causing a bite mark, a visible bodily harm to Gabriela Perez.
También la fiscalía acusa de haberse cometido una marca de una mordida que se ocasionó a Gabriela Pérez.
In violation of Georgia Law 16-523.1.
Lo que es un incumplimiento de la ley de Georgia 16523.
And on the fourth charge of criminal trespass,
y en el cuarto cargo de allanamiento de morada,
the defendant is charged that on the same day in Fulton County,
el acusado se le alega que el mismo día en el condado de Fulton
did knowingly and without authority enter upon the premises of Florencia Valadez Morales. Did knowingly and
el mismo día él cometió la entrada ilegal a la residencia de Florencia Valdés Morales.
For an unlawful purpose, that is, for battery and simple battery.
Por un propósito ilegal de golpes y lesiones simples.
In violation of Georgia Law 16-721.
Lo que es un incumplimiento de la ley del estado de Georgia 16721.
With regards to all four charges, you have and you will be entering a not guilty plea. Upon entry of this plea, the case will be scheduled for trial before Judge J. Roth.
Ante estos cargos, usted se declarará inocente y se llevará este caso a una cita ante el juez J. Roth.
At the time of the trial, the prosecutor has the complete burden to prove all four charges against you beyond a reasonable doubt.
En la ejecución de este juicio, la Fiscalía tendrá la responsabilidad de comprobar estos cargos más allá de toda duda razonable.
If the prosecution prevails, you could be convicted of one or more of these offenses.
Sí. La Fiscalía tiene éxito comprobándolo. Usted puede ser sentenciado por los 4 o más cargos.
Alpharetta, we just lost your video.
Hemos perdido el video con ustedes, Alpharetta.
Yo los escucho.
¿Puede o no?
Okay.
¿Puede escuchar?
We got it. Okay. If convicted, you could face a sentence of up to 1 year in prison and or up to $1,000 fine for each convicted offense.
Si usted es sentenciado, tendrá tiempo de encarcelamiento de 1 año y o $1,000 de multa por cada uno de los cargos.
Given this information, how do you plead?
Darle esta información, ¿cómo se declara?
Culpable.
Guilty.
No, Your Honor.
I've already explained it to him.
Ya le expliqué a él.
All right. The case is, Mr. Julian, do you understand that if you tell me guilty, I can sentence you to up to 4 years in prison?
este caso entonces, señor Julián, ¿usted entiende que si usted se declara culpable, yo puedo sentenciarlo hasta 4 años en cárcel?
Ok, ¿puedo hablar y explicar cómo pasaron las cosas o no puedo?
Can I speak and explain how things happened, or I cannot?
Your Honor, I thought we were moving forward understanding that it's a not guilty plea.
Y su señoría, yo entendí que seguíamos adelante con el caso con una declaración de inocente.
I've already explained that I've rejected his offer and that he is to be arraigned and to enter a not guilty plea. He's instead entered a guilty plea.
But he's saying he has things that he wants to bring forward, factual disputes. So I would say that that is a not guilty plea.
Yo ya le expliqué que he rechazado su declaración de culpabilidad, que le iba a leer los cargos para una declaración de inocente, pero él acaba de declararse culpable. Sí, pero él trata de decir algunas cosas para disputar en el caso.
Mr. Julian, if you decide to try to explain your case today, anything you say about the circumstances of the case, your statements can be used against you in prosecuting the matter at trial.
And I would advise him to exercise his right to remain silent. It's a not guilty plea, and that was your decision.
Señor Julián, yo ya le expliqué las circunstancias de su caso. Si usted desea decir algo hoy, todo lo que diga puede y será usado en su contra. Su abogada dijo, ya habíamos hablado que era una declaración de inocente o no culpable.
Mr. Julian, I'm going to ask you again, given the information sent to you by the court, how do you plead? Is it a not guilty plea as recommended by your attorney?
Entonces, señor Julián, basado en la información que le acabo de dar como jueza, le pregunto de nuevo, ¿cómo se declara? ¿Es inocente o no culpable como le recomendó su abogada?
Ok, me declaro inocente.
Okay, I plead not guilty.
This case is arraigned and further notice for trial.
Esto se le han leído los cargos y se continúa con la juicio.
Thank you. That concludes the case. Thank you, Alpharetta. Courtroom 2, I'm sorry, iPhone, just before, are there any other cases requiring the services of a Spanish interpreter?
¿Hay algún otro caso que requiera una intérprete en español?
I guess not. Thank you, Ms. Chansey.
You're
Appreciate it.
welcome. Have a good day, ma'am.
Thank you. iPhone,
Position number 54.
all right. This is State versus Christian Welsh. Are you Mr. Welsh?
Yes, Your Honor.
Mr. Welsh, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is it you, Mr. Tate?
Yes, Your Honor.
Mr. Welsh has been accused of hit and run, failure of the driver to stop or return to the scene of the accident. Count 2 is following too closely, and count 3 is operating a vehicle to no valid insurance. How are we proceeding, Mr. Tate?
This is a negotiated plea.
All right. Mr. Welsh, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Ms. Fong?
On count 1, the driving hit and run, 12 months probation, served 28 days, credit for time served 14 days. That is from July 5th, 2024, defensive driving course and a $300 fine. On count 2, the following too closely, we are requesting 12 months concurrent with count 1 with a $265 fine. On count 3, the count of no insurance, it would be 12 months concurrent with count 1 with a $350 fine. We are asking the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We
Ms.
stipulate- Yes, we do so stipulate.
All right. iPhone, I'm sorry, we lost the defendant. Sorry, your hand was in front of the screen. Okay. Mr. Welsh, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings in your case?
Yes, Your Honor.
Are you satisfied with the legal services you received?
More than, Your Honor.
I'm sorry, repeat?
You said more than, Your Honor. More than
And-
satisfied.
Okay. And Mr. Welsh, if you decide to plead guilty to these charges, this will result in your license being suspended for up to 1 year.
Yes, Your Honor.
Are you prepared to move forward with the plea, given that your license will be suspended?
Yes, Your Honor.
And has it been explained to you, if you enter a guilty plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to confront your accuser, challenge the evidence that will be brought in front of you, present your own defenses and arguments, and also have the state prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
How do you plead to one count of hit and run, failure to return to the scene of the accident?
Guilty, Your Honor.
How do you plead to following too closely and operating a vehicle with no insurance?
Guilty, Your Honor.
With regards to the hit and run, your sentence is 12 months to serve 28 days, credit for time served 14 days. You will report to probation. Does he have any holes, Ms. Atay?
No, Your Honor, he does not.
In that case, once you're released, you will report to probation on Monday, July 22nd, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. You will report to probation every month. Within 30 days of being released, you will enroll and complete a defensive driving class. You can do that online, and it is a minimum 6-hour class. Do you understand, sir?
Two things real quick. Can somebody write that address down for me? Because
It will be your discharge paperwork.
Okay, and then the second thing, you said the defensive driving courses, what do I have to do for that?
You will have to enroll in a defensive driving class. Probation can give you a list of schools that offer the class, or you can look for it online at the Georgia Department of Driver Services website. They have a list of schools, and you can pick the school that's most convenient for you. It is a minimum 6-hour class, and you must complete that within 30 days of being released.
Okay.
While you're on probation, you will also pay a $300 fine for the hit and run charge. For the following too closely, that will be 12 months probation concurrent with the hit and run charge. And that will be an additional $265 fine. For the operating a vehicle with no insurance, that will be 12 months probation concurrent with count 1, and that will be an additional $350 fine. Your total fine is $915 in addition to court costs and probation fees. You will make a minimum payment of $100 in the first month of probation and a minimum payment of $100 every month thereafter. Do you understand? Yes.
I'm right now, as soon as I get out, I'm planning on looking for a job, but it might take me a little bit longer to get my money together to be able to pay.
Your minimum payments of $100 must begin on the 2nd month of probation.
Okay.
You can make more payments if required, but it's minimum 100 every month.
Thank you.
No driving unless you have a valid driver's license, adequate insurance, and proper registration.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Next, we can go back to position 5 and 6, Mr. Brandon Brown.
All right, Ms. Vigiletti.
Mr. Brown would like to enter a plea today. He does have one request related to probation. I'm not sure that it's significant enough to rise to the level of a non-negotiated plea. Should I start with that so we can determine if this is negotiated or non-negotiated?
Please.
Okay, so, as you all know, the plea offer is asking for an MHET. Mr. Brown tells me, he has recently done one. He completed one at the Bradley Center, which is in Columbus, Georgia. He also recently went to an SUD program, a substance use program. He has been really trying to get himself on the right track. I'm sure you've read the police report in this case. That is the result of MH and substance use problems. If he is able to provide proof to the probation office of completing that MHET already, would you consider a non-reporting status on this probation?
No.
Okay. Then I do just need 1 second. Okay. Your Honor, Mr. Brown is ready to proceed and he will enter a plea this morning.
All right, Mr. Brown's already been advised of his rights and the misdemeanor offense has been brought against him. May I place him under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Falk, what's the recommendation for Mr. Brown?
Yes, Your Honor. The state's recommendation is 12 months probation with 88 days, credit for time served 44 days, from May 31st to June 23rd of 2023, and then June 29th of 2024 until today. Balance probated, stay away from 4735 and 38 in Union City, MHET or BHET, depending on what Your Honor would order. We were unsure what this defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Ms. Vigilante?
We do stipulate, Your Honor, and I do think that MHET is appropriate, and that has been something he is already working on.
Understood. Mr. Brown, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceedings in your case?
Yes.
And are you satisfied with the legal services you've received?
Yes.
You need to speak up, sir.
Yes.
And have you understood that if you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not have the opportunity to confront your accuser in a court of law, to have the assistance of counsel to challenge the evidence brought before you, to present your defenses and arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of the misdemeanor offense that has been listed on the accusation as presented to you by your attorney?
Guilty.
Your sentence is 12 months to serve 88 days, credit for time served 44 days. As you have satisfied your jail time, presently you do have a Muskogee County hold, so you'll be released to Muskogee County in order to address your outstanding case there. I'm not sure if you have any other holds right now, but presently the Muskogee County, once that case is resolved, you have to return to Fulton County and report to Fulton County Probation at 132 Mitchell Street in downtown Atlanta immediately upon your release from Muskogee County. You will report to probation every month. Within 60 days of your first report to probation, you must complete a BHET with a qualified healthcare provider. And if any treatment is required, you are to submit to that treatment at your expense. You will continue to report to probation for the remainder of the 12 months on this sentence. Failure to do so will result in your probation being revoked and a warrant being issued for your arrest. Do you understand, sir?
Yes, ma'am.
Thank you.
Thank you, Judge.
Position number 16, Johnny Phelps.
And the bench warrant for Mr. Brandon Brown, null pros.
Yes, Your Honor, the state submitted that.
Okay, position 15. Was that correct? 1-5?
1-6.
1-6, all right. This is State versus Johnny Felton at the jail court iPhone, accused of criminal trespass from July 3rd, 2024. Mr. Felton, you have a right to remain silent about the facts of your case. Anything you say, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Mr. Felton would like to enter a negotiated plea this morning, Your Honor, and I will say he is a little bit hard of hearing, and so if you could speak up when asking him questions.
Mr. Felton, my name is Judge Lal. Have you heard everything I've said so far regarding your case?
I don't know what you said. Oh, please, yeah.
Okay, so we'll need to get a, and how does he communicate, Ms. Vigiletti?
He communicates perfectly, Your Honor, but he does not always hear the question you're asking him, so we'll just need to be sure he can hear you.
Mr. Johnny Felton, my name is Judge Lal. Can you hear me? All right. Does your client use any kind of sign language?
Your Honor, I was able to speak with him yesterday, you know, when I was with him in person and speaking very loudly. We didn't have a problem. I don't know if it's possible for, I know the iPhone makes it more difficult.
We need
to join him and repeat your questions to him in person.
No, I'm sorry, Ms. Vigiletti. I'm not about to get into a screaming pitch over a plea.
Sure.
He needs to be in the courtroom where we can broadcast the closed captions.
Yes, and I would be happy to repeat your questions if they need to be repeated.
Yeah, but I cannot do it with him being in a separate location.
Well, I'm gonna have to get the mayor officer to come and get him because I think it's more than just a hearing problem. I think it's MH along with the hearing problem. So I'm not gonna bring him down by myself.
Understood. I'm going to, Ms. Vigiletti, I'm going to reset this case for you to confer with him.
Your Honor, this is a time-served balance suspended plea. He has been here for 2 weeks.
If there is an indication of MH situation, I'm not about to move forward with the plea.
And Your Honor, I did speak with him for a long time. That's not my assessment of him at all. But if he has to be reset, I will send a social worker to visit him.
All right. I'm going to reset it to Mr. Jordan or Ms. Champion. Can I add it to next Tuesday's calendar?
Yes, ma'am.
All right. It's going to be added on as next Tuesday, which is going to be the 23rd of July. Deputy, please inform him either in writing or you can speak to him loudly that his case will be addressed on July 23rd. And he has to be in the courtroom with his attorney next to him.
Okay.
Thank you. Next case, please.
We can go to position number 4, Mr. Ed Andrews. That's related to the end. Yes.
Your Honor, Tracy Crawford is on Zoom for PAD with regard to Mr. Andrews.
Okay. This is.
We might need to chat to her.
She's right there.
Did you say Andrews or Anderson?
Andrews.
Position 4.
The add-on case, Your Honor.
Oh, I'm so sorry. Okay. Let me get to that calendar.
And Your Honor, I do have an announcement on the add-on case.
All right. This is State versus Adonis Andrews, 24 CR 3895E. Mr. Andrews, you have a right to remain silent, and anything you say about the facts of your case, the statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. All right, let's see what's.
This was a recidivist shoplifting that we were just dealing with the bond as a residual matter.
And that's the state's announcement.
And who did you say is with Pat?
Tracy Crawford, she's on video.
All right, Ms. Crawford?
Hello, good morning, Your Honor. How are you?
I'm doing well. Thank you, Ms. Crawford. If you please raise your right hand. Do you saw other right hand?
Sorry.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
All right.
Your Honor, I think my announcement can kind of short
Go
circuit.
ahead. Yeah, please go ahead.
So the case was reset from Tuesday because the state was awaiting the transfer order to be signed by the DA's office. They signed it yesterday, and I submitted it to Judge Morrow since he was the judge who handled court on Tuesday. He assigned that in 3 other transfer orders that we were waiting on, and all of that has now been transmitted to the clerk's office in Superior Court, and the case has been moved up.
Ms. Crawford, this case has now been upgraded to a felony charge. Is this something that Pat gets involved with?
Yes, we help people with felony charges.
Okay. And what would you like to tell me about this case?
I was just put on the court. The attorney was saying that we was interested in stable housing for Mr. Andrews. At Pat, we are able to provide him with shelter placement. I'm not sure if you're familiar with the PAD program, but we had 6 people who are incarcerated and connect them with services. So with Adonis, I am his care navigator. So we were working on getting him connected to mental health services and getting him on a track with permanent housing. But the first step is getting him into shelter placement. So we are just trying to advocate to get him released so we can continue to work on these goals and get him, more self-sufficient. And so he wouldn't necessarily be put in the position that he is now. And so he'd have more resources available to him.
Well, currently, Judge Morrow has given him a $1,500 signature bond through pretrial services to be released to his mother. Ms. Falk, do you have any objection to being released to PAD resources?
Your Honor, my objection would be we no longer have venue of this case. The minute Judge Morrow signed that order yesterday, we lost venue.
No. I can still amend the bond order as long as the case is not docketed with the district attorney's office. So that's the question I have.
The state would ask that the defendant remain as being released to his mother, Miss Tina Chris.
Right. Mr. McLean?
Your Honor did start the case off before Judge Morrow, and the idea at that time was to release him to his mom, but his mom feels that it would not be appropriate. So then he told us about PAD, and we got hold of PAD, and they're saying that they can provide housing. I don't know what date he could be put into the shelter.
Right. We work with numerous shelters, and I had spoken with his mother as well previously. She said that she wouldn't be open to having Adonis staying with him right now. So we can work on shelter.
All right. If she is willing, then she needs to understand that she needs to come pick him up because that's what the bond order says.
So she must pick him up and sign for him. And if she gets down here today or tomorrow to do that, I think that sounds like it works.
And then she will work with Pat. But right now, I mean, it's this is a no-brainer. If mom is willing to come pick him up, that's what the order says.
Okay.
And since Pat has chimed in, I mean, I'm grateful for that because then now there is a resource for the mother to reach out to Pat and take advantage of the programs available to him.
Right.
Okay.
So
Thank you, Judge.
I don't need to do a separate order though. Okay.
No, you don't. It's just that. Just let him know that his case is now with Superior Court and it's a felony charge.
Right.
So Judge, I'll be released today?
You'll be released once your mother comes and picks you up. And then you need to listen to your mother and you need to listen to PAD resources. If you get in trouble again, all this help and benefit is going to fly out the window and you're going to stay in jail until you go to trial.
Thank you, Tracy. Thank you, Judge. Thank you, Mom.
Okay, thank you, Mr. McLean. Next case, please.
Hello.